Basically 75 years after the massacre at Wounded Knee in 1890, American Indians seemed largely invisible to mainstream America. The 30s saw that whole flurry of federal programs to aid reservations and native communities under the Indian New Deal. But throughout most of the 20th century, mainstream America really focused on other matters. They're just kind of not concerned with the consequences of the frontier process. In fact, until the 1960s, the publisher of the Time Life Corporation and all of the books and magazines and newspapers that fell under that banner, their publisher was a guy named Henry Luce, and it was his policy to just not publish any articles about American Indians. And before you hop on the discussion board and ask why, the answer is racism. Now, this kind of historical amnesia, I guess, will change in the Nixon-Ford years, especially from 69 to 77. The American public had to take notice of the historic problems and the disastrous policies that Native people had been living under. And they're going to be forced to do that by very active Native rights groups, most especially AIM, the American Indian Movement. They're going to, Indian activism had been building for a while. Right? There's the National Council on American Indians that had been founded in 44. There was the National Indian Youth Council founded in the early 1960s. There's going to be Indians of all nations who are going to lead probably the most famous demonstration of the 20th century by Native people, and that's going to be the occupation of Alcatraz, which we'll talk about in more detail in a minute. Now, all of this activism was the manifestation of so much frustration that had been building for years. And those are feelings that are traceable well back into American Indian history. By this point, it's been like a quarter century after the end of World War II. And the federal government's policies in that period were incredibly destructive to Native people and their communities. Now, policymakers love to use very euphemistic terms to describe their Indian policy, like they would call it emancipation or readjustment or federal withdrawal. But if they wanted to be blunt, they would use termination, like we talked about in the last lecture. Now, the policy of termination was both a philosophy and specific federal legislation applied to Native people. As a philosophy, termination encouraged the assimilation of Indians as individuals into the mainstream of American society, so that they would cease to culturally be Crow or Chippewa or whoever they were, while also at the same time advocating the end of the federal government's recognition of and responsibility for the tribes and the contracts that the government had made with those tribes in the form of treaties. To accomplish that objective, to reach the objective end of that philosophy, Congress passed termination laws that fell into, like we talked about, basically four general categories. First, there was the end of the federal treaty relationship and the trust responsibilities to certain specified Indian nations. Second, there was the repeal of federal laws that had set Native people apart from other American citizens. Third, there was the removal of restrictions of federal guardianship and supervision over certain individual Native people. And then fourth, there was, like we talked about, that transfer of services away from the BIA to mostly state and local government agencies, sometimes to Indian nations themselves. The termination era, basically at its height during the Truman and Eisenhower years, but still to an extent carrying on during the Kennedy-Johnson years as well. That ended federally recognized status for 109 Indian groups all total. The termination laws also removed protection for Indian trust lands. It made it easier to lease or to sell those lands, which that is something that was welcomed by some members of some tribes, but largely it was not welcomed by Native people themselves. These laws shifted responsibility for Indian health care from the BIA to the Department of Health, Education, and Welfare, and then really to the states, which, like we talked about, led to a disastrous fall in accessibility of health care for Native people. Members of Congress justified both the termination laws and some other programs and laws that were damaging to Native communities by kind of exploiting the tensions and the fears created by the Cold War. For those of you who haven't taken your U.S. history survey yet, the Cold War is this period when the U.S. and the Soviets are not directly fighting each other, but we really hate each other. They are communists, we're capitalist, we're free market. They are living in slavery under the grim oligarchy of the Kremlin, as Churchill once said. And basically anytime an American politician wanted to get support for his program, all he had to say was, it's national security, we got to beat the commies. And so they described reservations and tribal communities as, well, like we talked about in the 30s, as communist experiments. So, okay, let's get rid of them. That's too communist. They justified funding projects that undermined Native sovereignty and, in many cases, the economic foundation of reservations by saying, well, it's for national security. So, like, there's the flood control programs and hydroelectric dam programs and mining programs that are carried out on Indian land, usually without permission of tribal leaders. And politicians say, well, we got to have the power, we got to have the oil, we've got to have the whatever it is to fight the commies. These projects affected many Native communities from New York to New Mexico to North Dakota. The federal government will eventually provide some settlement to Indian nations for the damages done, but money from Washington can't replace massive land loss, destruction of traditional fishing sites, in some cases destruction of sacred sites. You can't replace that. The urban migration of American Indians didn't start with the relocation programs in the 50s. That era did encourage the urbanization of Native people, but it didn't start the problems. We talked about relocation. We talked about, in 1951, Commissioner of Indian Affairs at that time, Dylan Meyer, established these relocation offices in Los Angeles and Chicago and Denver at first, and then a bunch of other places, and funneled Indian relocatees away from the reservations. And through these placement offices, they deliberately sent Native people to urban areas, usually as far from home as they could get them, which kind of echoes the federal boarding school mandates. And they did that as a way to, like immersive language learning, right? They just kind of throw you in the deep end. This is supposed to acculturate them very quickly to the white mainstream. And it is a component of the overall termination policy. It's a way to end the reservation system, which many politicians saw as working against assimilation. So they want to get rid of the reservations. Many American Indians, just like European immigrants to the United States, they saw a move to the city as a way, hopefully, to provide for their families, but often that didn't really happen. Federal officials did very little to improve the system, but they did speed up the relocation program. So we get increasingly larger and larger urban Indian communities from LA to New York. And the poor conditions that these arrivals typically faced spawned what came to be known as Red Power activism. And the first explosion of that came at Alcatraz in San Francisco Harbor, right after a fire that had destroyed the Bay Area's American Indian Center. The group that took Alcatraz, and there was suspicion of deliberate arson. So the group that took Alcatraz included a significant number of people from the plains who were relocatees or the children of relocatees. Now, on the state level, American Indians still faced restrictions on their civil rights in the post-World War II era. Congress had awarded state jurisdiction over criminal and civil matters to various states, which was in contravention of the Major Crimes Act, but whatever. And various states continued to restrict Indian fishing and hunting rights, even after World War II. Some state constitutions, especially the western states that had large native populations, those states continued to prevent Indians from voting via their state constitution. But there were a few moments, like a few points of light, that suggested change coming in the future. There was a case in 1948, not long after the end of World War II, called Harrison v. Levine. And it's one of the more important cases in American Indian legal history. Harrison v. Levine. Harrison v. Levine, Laveen. That came before the Arizona State Supreme Court in 48. Frank Harrison and Harry Austin, who were both members of the Mojave Apache Indian tribe at the Fort McDowell Agency. They were World War II veterans. They had fought in the U.S. military, and they went to Scottsdale, Arizona, which is in Maricopa County, which, if you know anything about modern immigration issues, Maricopa County has real problems with racism toward indigenous people, toward Hispanic people, still in the 21st century. So they went there to register to vote, and Roger Levine was the county recorder, and he wouldn't let them register because they were Indians, even though the Indian Citizenship Act had passed in 1924. These men are citizens, and they're war veterans, and he won't let them vote. And what followed was a major test case on behalf of Indian voting rights. And it was largely orchestrated by the National Congress of American Indians in conjunction with the ACLU, the American Civil Liberties Union. Harrison and Austin and their attorneys argued that Indians attempting to register to vote had all of the qualifications for suffrage, for voting rights, that was set forth in the Constitution and laws of the state of Arizona. And they insisted that their rights as citizens guaranteed under the U.S. Constitution and under the Arizona State Constitution had been violated. And the Arizona Supreme Court agreed. The Arizona State Constitution had this phrase, person under guardianship. A person under guardianship was not allowed to register to vote. And the court said that should no longer apply to Indians, even though it once had. But even after that case was decided, there were still other Western states that continued to restrict Indian voting rights for another decade or more. Now, the outburst of Native activism that that we see really like burst onto the scene at Alcatraz. It's, you know, it's based on all of these frustrations. It's based on it's based on the fact that nobody's kind of listening to what Native people themselves say they need. It's the government going back to the way they had before Collier, and doing things in a very paternalistic way. So in November of '69, this small, relatively small group of idealistic, mostly young Native people, working with the leadership of this group called Indians of All Nations, they seized Alcatraz Island, and they were occupying it on behalf of Indians of all nations and the original tribe that had once lived there. Alcatraz, I'm sure you know, had been used as a federal prison. Of course, originally, like everything else in the United States, it was Indian land, and the United States had signed a treaty with the tribe that lived there. And the treaty said, once the United States is no longer using the island, they will return it to that Indian nation. Well, the prison at Alcatraz had shut down in 1963. And at that point, the government hadn't turned it into a tourist trap yet. It's just sitting there, and, you know, the concrete is crumbling and nothing's being done. So Indians of all nations said, hey, treaty says you're going to give it back. Why don't you give it back? And the government is like, because reasons. I don't know. We don't care. We're not going to do it. So the occupation happens. It was organized mostly by this guy named Adam Nordwall, Adam Fortunate Eagle Nordwall. He was Ojibwe, and he's got a lot of contacts in the media. And he got them to focus on, he got them to kind of equate the occupation of Alcatraz with their own imprisonment in poverty and federal neglect on reservations and in urban areas. And a lot of the early news attention focused on the spokesman for this occupation. That was Richard Oakes, who was very photogenic. He was Mohawk, and he became the spokesman for the Indians on the island. Off the island, Nordwall is the one who conducts most of the negotiations with federal officials, who of course immediately demand that Native people remove themselves, and they threaten to invade Alcatraz with the military and federal marshals. And the newspapers presented this as an Indian war, but this time they see the Indians as the good guys, as people who are fighting for their rights against a hostile invader. This hung on for more than a year. They started the occupation in November of '69. They didn't leave until June of '71. And this will have a direct influence over the next 3 decades, not just in bringing attention to Native issues in a really flashy way, but also in creating the leaders of the next several decades of Native communities. Those who were on the island and those who were on the mainland, you know, making sure that they had supplies and running the logistics and dealing with the media. Many of them became prominent in their tribes, including Gerald Hill, who will become the chief attorney of the Oneida Nation in Wisconsin and the head of the American Indian Trial Lawyers Association. And also this young lady, who, if you're Cherokee, you may recognize. That's Wilma Mankiller. She will go on in the 1980s to become the first female principal chief of the Cherokee Nation. And she got her start in political activism here at Alcatraz. Her family had been relocated. She had a brother and a sister who were on the island in the occupation, and then she helps off island to run the logistics and make sure that everyone has supplies. That's how she got involved. In the midst of everything that's happening in this period, you know, we've got the Vietnam War, we've got a change in the civil rights movement away from the original church-based movement toward becoming much more militant. We've got the second wave of feminism. We've got all of these social upheavals. These Native people are attempting to focus America's attention on issues that America had wanted to forget about. And they are extremely successful in this. Now, Richard Nixon is president throughout the Alcatraz occupation. And the presidency of Richard Nixon was kind of a turning point in the modern history of American Indians. Because of his programs and initiatives that affected Native lives and welfare, today he is often very highly regarded in Native communities, especially by folks who were old enough to have lived through this era. Certainly not perfect, even on Native issues, but really good on Native issues, at least until he gets distracted by the whole Watergate thing, and then he's going to forget about literally everything else he needs to do. In July of 1970, so this is a year into his first term, he delivers a message to Congress about federal Indian policy. And his message really enunciates a clear shift in what his policy focus is going to be. He called Native people the most deprived and isolated minority group in our nation. And he acknowledged, and was the first president to publicly acknowledge, that from first contact, American Indians have been oppressed and brutalized, deprived of their property, denied the opportunity to control their own destiny. And if you will think back to the last video that you watched when we talked about Clyde Warrior and the founding of the National Indian Youth Council, the opportunity to control their own destiny, that very much echoes that phrase that so many youth activists, regardless of race or regardless of where they're coming from, like to use. You know, empowering ordinary people to make decisions about their lives and the lives of their communities and their destinies. And so the President of the United States is using this activist rhetoric. Nixon acknowledged the failures of past government policy. He said that even federal programs which were intended to meet their needs were frequently ineffective and demeaning. Nixon then rejected forced termination, and he turned attention to ending the termination policy. He said that the federal government, federal programs for Native people aren't charity. He said it's a legal obligation. He said that because the U.S. had signed the treaties, the U.S. had made contracts. Indians, on their side, had ceded claims to vast tracts of land and had accepted life on reservations in exchange for the U.S. government's promise to provide them with a standard of living comparable to that of other Americans. So Nixon said that terminating that relationship is breaking a contract. He said it would be no more appropriate than to terminate the citizenship rights of any other American. And Nixon went on to say that the termination policy that had been going on for the last decade and a half, almost 2 decades at that point, had clearly failed. The termination policy had proven very obviously harmful to the tribes and communities that had been terminated. Nixon said that the threat of termination had also generated a lot of fear and distrust of all federal programs. And that distrust had weakened the effectiveness even of programs that weren't a part of termination. He said that of the Department of the Interior's programs that directly serve Indians, only 1.5% were actually under Indian control. Only 2.5% of health, education, and welfare's Indian health programs were being run by Indians. And so he committed to bringing more Native people into the federal bureaucracy to take control of the decisions that affect their lives and the destinies of their communities. And Nixon very much recognized that he was taking a historic step in reversing policies. And he emphasized that in place of policies that oscillate between the extremes of forced termination and constant paternalism, he wanted a policy in which the federal government and Indian communities could play cooperative and complementary roles. And he concluded that the Indians of America, he said, need federal assistance. The federal government also needs Indian energies and Indian leadership if it is going to be effective. Now, two events in 1972 and 73 had a direct bearing on the reevaluation of federal Indian policy. First was the takeover of the Bureau of Indian Affairs building in Washington, D.C. in late October of 72. And then there was the occupation of the village of Wounded Knee in the spring and early summer of 73. President Nixon, okay, by this point, set the stage. So by this point, Watergate has happened, but almost nobody outside of the president's inner circle knows that it has any connection to him yet. So, okay, for those of you who don't know, you probably heard of Watergate. So this was a break-in at Democratic Party headquarters in the Watergate building in Washington, D.C. And that took place in the summer of 72, in the run-up to Nixon's re-election. Now, the men who were responsible, the men who broke in to Democratic Party headquarters, Nixon's Republican, were former employees of the campaign to re-elect the president. We don't know what they were doing. Were they looking for stuff? Because they threw crap everywhere. Were they looking for stuff? Were they planting bugs? They were super incompetent because, like, a security guard saw their flashlights and immediately came and called the police, and they were arrested. But in the fall of 72, October of 72, the re-election hasn't even happened yet, and nobody has connected these men with President Nixon. Nixon has been informed that they are his former employees. He has also been informed that members of his administration working with him in the White House knew that they were going to do this and paid them off afterwards to keep their mouths shut. And Nixon himself didn't order the break-in. He didn't know that was going to happen. Once he finds out that they were connected to him, that's when he starts doing illegal things to try and make sure that the connection is never discovered. That's really what he did wrong there. So Nixon is kind of distracted. In October of 72, he's distracted by the fact that the election has not happened yet and he is still campaigning. And he's also distracted by a growing worry that his potential connection to the Watergate criminals is going to be uncovered. So he started to take his focus away from his domestic policies, including federal Indian policy, and put more of his attention and his effort into covering his tracks that he didn't even really need to cover. Anyway, that's a rant for a different class. So Nixon had made a promise that he would meet with tribal representatives at the BIA offices in Washington, D.C. in October of 72. So representatives from a bunch of different tribes, they caravan across the country. They start out on the West Coast, and more people join as they come through the states heading toward Washington, D.C. And they arrive in D.C. They go to the BIA offices expecting to meet with the president to talk about how he's going to implement the hiring of more Native personnel and how he's going to implement improvements to Indian education that he had been talking about, and how is he going to implement improvements to the healthcare system like he'd been talking about. And the president didn't show up. And that first day, they were told, oh, he's He's caught up in a meeting. He can't be here. He'll come back tomorrow. So they come back tomorrow, and the president still doesn't show. And then they're told he's too busy. There's too much going on, re-election, all that stuff. So he can't meet with you. I guess you guys can just go home. And the representatives there are like, F that. We were promised a meeting with the president. So if he's not going to come to us, we're just going to sit here in the BIA until we're kicked out. So they stayed. They literally took over the offices of the Bureau of Indian Affairs. They camped there. They there's a little bit of vandalism. There's one small, very minor, hardly anything, tiny fire. Mostly what they do when they leave, they're there for about a week. Mostly what they do when they leave is take a whole bunch of files, copies of treaties, copies of legal decisions, research that the government had conducted on various tribes to help those tribes in their court cases usually against states, but sometimes against the federal government as well. And so that came to be known as the Trail of Broken Treaties BIA occupation. 3 months later, 3 months after the end of this, members of the American Indian movement, led by Russell Means and Dennis Banks, took over the village of Wounded Knee, South Dakota. That is the site of that massacre from 1890. It's on the Pine Ridge Reservation in South Dakota. And if you watched the video that I posted about that massacre, you'll recognize this church. This is the church where the bodies of the wounded were taken so that reservation doctors could look after them. It was still standing. It was burned down later in 1973, maybe 74. But it was still standing when the Wounded Knee occupation took place. There are a lot of issues behind this particular event. AIM, the American Indian Movement as an organization, had been founded in Minneapolis in 1969, and it was founded by young relocatees. Mostly the original members were young men. They'd kind of envisioned AIM as being like the native version of the Black Panthers. An organization that is, on the one hand, very political, is trying to affect political change, but on the other hand, also provided social services. So like the Black Panthers provided school breakfast programs before the United States anywhere had school breakfast programs. And they provided like access to doctors and dentists in communities that didn't have any. And AIM kind of envisioned themselves doing something similar. What they became best known for instead was really spectacular, often violent, political demonstrations. And I'll link another video for you guys. It's part of the We Shall Remain series, which really you should just watch like the entire series. There are 5 parts to it, but I'll link the one about this occupation here. And they talk in the video about, you call in AIM when you need media attention, because the media will follow them, because they do big, spectacular things. But it's also kind of a crapshoot when you call them in, because a lot of them are angry young men who just want to F shit up sometimes. I mean, Means and Banks and the other leaders, they are often actually military veterans. They can be extremely focused, but not all of the membership is extremely focused. And so they had been making a name for themselves. And Oglala Lakota elders at the Pine Ridge Reservation were seeing their community in crisis. We had talked about a few lectures ago, we talked about the rise of mixed blood, acculturated tribal leaders, and how sometimes they would treat unfairly the traditionalists, traditional chiefs, full-blood people, older people, and that's what's happening on the Pine Ridge Reservation. The chairman of the Oglala Sioux Nation at the time was Dick Wilson, and he had essentially like a special police force of men who were loyal to him rather than to the Oglala Nation. And he called them the guardians of the Oglala Nation, Goon, and then would get very publicly insulted when people would call them his goon squad, but he named them the goon squad anyway. So Oglala elders, the traditional chiefs, were looking around for, I mean, they had petitioned the federal government to come in and do something about this. Trying to hold an election to get a new chairman had gone badly because of fraudulent results. It was very obviously a fraudulent election result that put Dick Wilson back into power, and the government wouldn't do anything about it. So they said, you know what? We need attention. We need somebody to notice what's happening here. So let's call in AIM. It might be a mess, but there's also somebody's gonna listen. So they call in AIM, and this occupation lasts for several months. Almost every day, representatives of AIM, especially Russell Means, who's kind of taking a leadership position here. This is Russell Means right here, and then this is Dennis Banks next to him. If you watched that video about the residential schools, that was Dennis Banks. So here he is as a much younger man at the occupation of Wounded Knee. Almost every day they would meet with their senator. This is one of their senators of South Dakota. They met with representatives of the Justice Department. They asked for the Secretary of State to come and talk to them, Henry Kissinger, because from their view, they are a sovereign nation. And it is the job of the Secretary of State to be the go-between for the U.S. with other sovereign nations. But he doesn't see them as important enough, so he doesn't come out there. They do actually get heard briefly by the United Nations. They send Frank Foolscrow, was the oldest traditional chief. They send him and some other younger people to help him to the United Nations to talk about human rights violations in the United States. And they ask for the Oglala Nation to be recognized by the UN as a separate and sovereign nation. They don't actually get that, but by the time the takeover ended, several Indians and non-Indians had been wounded, and 2 Native people had been killed during this occupation. And Nixon's response to this happening, by the time the occupation of Wounded Knee is happening, the Washington Post investigation into Watergate has begun, and Nixon is now real nervous. So his response to the occupation of Wounded Knee is even less sympathetic than it was to the Trail of Broken Treaties. He orders the FBI to wiretap AIM leaders. Russell Means and several other AIM leaders are going to be arrested and charged with various things, some of which are legit and some of which are just bullcrap, designed to keep them out of Wounded Knee so that they can't help. And the Wounded Knee occupation will effectively come to an end here. In the lead up to these events, Nixon had actually been taking some of the steps that he had promised he would take. Back in 1970, Nixon signed Public Law 91-489. That returned Ozette, Washington to the Maka Nation, and that was celebrated by Indian communities across the country, the return of traditional sacred land. A couple months after this, he signed federal legislation that returned Blue Lake and 48,000 acres to the Taos Pueblo. Blue Lake was sacred tribal land that had been dubiously acquired by the federal government in 1906 and it had been included in the National Forest System by President Teddy Roosevelt. And so now it is being returned to the Taos Pueblo. In 1972, early 72, before the protests start, Nixon had signed federal legislation returning 21,000 acres to the Yakima Indians in Washington. Now, there were also other improvements that happened under Nixon before he got distracted. And even some that happened after the shit hit the fan and Nixon knew, like, there's no more point in fighting this. So, late December 73, Congress, with the support of the Nixon administration, restored the federal status, the federal recognition of the Menominee in Wisconsin. That's that tribe that had been terminated in that first round of terminations. We talked about them. And as a result of that, other Indian nations that had been terminated as well, like a bunch of rancherias in California and the Klamath in Oregon and some other people, they also were restored to their federal status. They became re-recognized, which then means that they are eligible for federal programs. They have access now to the federal courts to protect themselves from the states. In June of 72, it's like a few days after the Watergate burglary, the Commissioner of Indian Affairs at that time, Louis Bruce, extended Indian preference in employment in the BIA, which means if you have two candidates of equal qualification, they will hire the candidate who is a tribal member. Now, if they're not of equal qualifications, they'll take whoever's more qualified. But if they're equal, take the tribal member. In 74, that had been challenged actually as discriminatory, but in 74 the Supreme Court upheld that decision. Nixon's positive legacy also included Indian education. In 1969, he had convened a special subcommittee on Indian education, and they issued a report that labeled the federal government's Indian ed policies as a failure of major proportions and a national tragedy, their exact words. So over the next decade, Congress, with the support of Nixon, as well as Ford and then Carter, substantially increased funding for Indian schools. They encouraged the building of normal schools on reservations, and they began the process of closing some of the more criticized Indian boarding schools. Although some of them will stay, some of the boarding schools will stay in effect. I don't think Chilocco closed until the late 80s, maybe early 90s. But that was far from the worst of them, and they focused really on the ones that had the worst reputations. The first of two major pieces of Indian education law was passed during the Nixon years. That would be the Indian Education Act. The Indian Education Act. That was in 1972. And the Indian Education Act provided funding for urban and rural and non-reservation and even terminated tribes, education funding for them. The second really important piece of Indian education law was passed during the Ford presidency. That is the Indian Self-Determination and Education Assistance Act. The Indian Self-Determination and Education Assistance Act. And that was probably the most important piece of federal law dealing with Indian ed since the Collier years. Among other things, that law allowed Indian nations to run educational and health programs themselves, which was like a revolutionary principle after 150 years of BIA paternalism. 3 years later, building on these first two remarkable pieces of legislation, President Carter signed Public Law 95-561. Public Law 95-561, which increased funding for Indian children in the public schools, while also promoting greater parental involvement. Now, just like with most federal laws, the success of these and any other program depends on whether or not Congress is willing to fund it this year. And in that regard, there have been periodic shortfalls since the 1970s. Despite his sincere efforts in many ways, Nixon's support of laws affecting Native people didn't always resolve long-standing problems. And in some cases, he supported things that caused more trouble, that caused us to have to correct course later on. One of those kind of missteps was the Navajo-Hopi Land Settlement Act in 1974. It was, I think it was actually signed by Ford after Nixon had resigned, but Nixon had supported this when he was in office. It was supposed to resolve a 90-year dispute over the joint use area on what was actually the Hopi Reservation. This was about 2.5 million acres in New Mexico. It had been established for the Hopi in 1882 to resolve Hopi complaints about the Navajo encroaching on their lands. And so the president at the time, that was President Arthur, said, okay, if the Navajo are, violating your boundaries and using your land, here's an extra 2.5 million acres, quit complaining about it. And then the Navajo came onto that land. So, I mean, literally thousands of Navajo, with the federal government just kind of ignoring it. They steadily occupied that 2.5 million acres, and the two tribes steadily bickered at each other for almost 100 years about it. The 1974 law, the Navajo-Hopi Land Settlement Act, called for the removal of the Navajo in that disputed region, which just really elevated tension between those tribes so much that the New York Times, which usually didn't report on Indian issues at all in this period, A, they reported on it, and B, said, this looks like war. And the dispute continued bitterly and sometimes violently until federal courts ordered mediation between the two tribes in 92, 93, real recently. Perhaps more significant was another law that had to be corrected, but one that we have heard quite a bit about recently, like in 2020, and that's the Alaska Native Claims Settlement Act. The Alaska Native Claims Settlement Act. That was ANSCA, is what it's called. Under this act, Alaska Natives were able to get about 44 million acres of land and nearly $1 billion in compensation for the land that they were not going to get back. It also divided Alaska into a dozen geographic regions, each under a different regional tribal corporation. Those corporations were established to manage those lands and promote economic development. This act had overwhelming bipartisan support in Congress. It was endorsed by Senator Ted Kennedy in Massachusetts. It was endorsed by Republicans. One of the problems caused by the original 1971 law was that not those dozen tribal corporations didn't actually represent all of the tribes in Alaska. Some of the tribes were shut out of that. And of course, very recently in 2020, during the COVID-19 crisis, there have been questions about whether federal relief money should go to profit-making corporations as opposed to tribes with democratically elected Republican governments. And I'm using Republican in the classical sense, not in the sense of being controlled by the Republican Party, but governed by the people rather than by a for-profit board of directors. Now, in the Reagan years, there were amendments to the Alaska Native Claims Settlement Act that improved some of those problems, but clearly did not solve all of them, especially the problem of whether or not the corporations adequately represent Native people in Alaska. In 1997, there was a Supreme Court case about this, that the court unanimously declared that Alaska Indian lands did count as Indian country, which made it not subject to state jurisdiction. And of course, Alaska screamed about that. So that was another issue with the original law. By the time Nixon resigned his office in August of '74, there were many more Native people holding office, holding elected office in Washington, D.C., many more Native people working in the Bureau of Indian Affairs, and old policies that had been proven harmful were under attack. Within 3 years, the position of Commissioner of Indian Affairs was elevated to the level of Assistant Secretary of the Interior, which was a move supported by every major Indian organization in the country, and had been since at least the takeover of Alcatraz. Officials in Washington seemed more responsive to Indian needs and desires, especially responsive to criticisms of how paternalistic and colonial the administration of Indian Affairs had been in the past. In the wake of this new visibility of Native people, Congress established the American Indian Policy Review Commission. The American Indian Policy Review Commission in January of '75. And they called for an exhaustive investigation into the historic and legal status of American Indians. And they required, when they created this commission, they required that at least 5 of the 11 commission members had to be of Indian ancestry. The other 6 were congresspeople. And also, one of the other cool things about the makeup of this commission is they showed some understanding of the diversity of the Native world, which, you know, the federal government had not often recognized before. So when they created this commission, 3 of the members were from federally recognized tribes with reservations. 1 of them came from an urban Indian community, and then 1 of them came from a non-federally recognized tribe. The group set up a bunch of task forces, and they made separate reports and recommendations on everything from healthcare and economic development to acknowledgement of tribes that had lost their federal recognition, or in some cases had been recognized by the state but never by the federal government. A lot of the modern impetus for federal recognition came from the American Indian Policy Review Commission, although the movement can be traced much, much further back. Restoring federal recognition has been a demand of Native communities since termination began. As of, you know, I don't actually know right now, I need to look that up, but I know that as of 2001, the government federally recognized 561 Indian tribal governments. In January of 2001, the Interior Department recognized its trust responsibilities to 2 Alaska communities who had been left out of the setup of the corporations. That's the King Salmon tribe and the Chinook tribe of Kodiak. And they also restored federal recognition to the Chinook Indian Nation in Washington. Just a week before they did that, President Clinton had signed the Omnibus Indian Advancement Act, which restored federal recognition to the Groton Rancheria in California, which had been terminated back in the 50s. And that's the same law for those of us here in Northeast Oklahoma. That is also the law that extended federal recognition to the Shawnee tribe of Oklahoma, also known as the Loyal Shawnee. So they had been forcibly joined with the Cherokee Nation, which is such a slap in the face. So like the Loyal Shawnee, the reason why they were called the Loyal Shawnee is because during the Civil War they had sided with the United States. They had fought to defend the United States against the people who committed treason. And the Cherokee, as we talked about, the Cherokee Nation officially had signed a treaty with the Confederacy, even though not all Cherokee had wanted that. And in gratitude for the service and the loyalty of the Loyal Shawnee, the federal government after the Civil War had required them to if they want federal recognition, if they wanted any kind of federal status, they had to be Cherokee. And so, like, I've got friends who, growing up, we were in the Cherokee Nation, but they were actually Shawnee. And it wasn't until 2001 that the Shawnee tribe of Oklahoma got federal recognition again. Now, today, federal recognition of a tribe can be achieved in 3 ways. First, you can go to court. The tribe can go to court to force the U.S. to recognize their trust responsibilities. And that's usually based on a treaty. The U.S. signed a treaty with this tribe, broke the treaty, frickin' stop it, recognize us again. The second way is to go through Congress, have Congress literally pass legislation that recognizes a tribe. And the third way is to go through the BIA. The Bureau of Indian Affairs has a branch of federal acknowledgement. That is extremely long, very difficult, often convoluted. And so not a whole lot of tribes actually try to get recognition through the BIA, which seems counterintuitive, doesn't it? It seems like that would be the way that most tribes could regain their recognition, but in fact it's so difficult. To get federally recognized status, or to regain it if your tribe had been terminated, that it fosters community pride, absolutely, and it allows that tribe to gain a more equal footing in the native world. But it also provides them with access to federal Indian programs, and it allows them the ability to sue in federal court to have their land returned. It allows them to seek out other federal protection, particularly against state governments. In more recent times, federally recognized status often allows Indian nations to put their land into federal trust. So that is a whole change in attitudes toward that particular policy, the idea of land in trust. Now, many tribes had originally not wanted that because it was handled in such a paternalistic way, as the U.S. knowing what was best for the tribes. But now, handled in a partnership, in a cooperative way, it's something that most tribes strongly prefer, to have the land in trust. That gives them special tax advantages, and it also protects that land. That strategy has been used a lot over the last 20, 30 years, especially by Indian nations that are starting businesses, like gaming establishments. Now, going through the BIA, that path didn't even exist until 1978. There was no way to petition the BIA before that point for reestablishment of your status. And it's really difficult to do. It requires you to have all sorts of historical evidence and genealogical evidence and a whole bunch of paperwork. And many Native communities have not been able to secure federal recognition because it is so difficult to get the kinds of evidence that the BIA wants to see. It's really time consuming, it's expensive, it is politically charged. Sometimes it's kind of demeaning, answering to someone in the BIA about why you don't have paperwork from 1823 when nobody had paperwork in 18. There's a lot of roadblocks to regaining or getting for the first time federal recognition. And one of those roadblocks is that some federally recognized tribes themselves do not want Washington to recognize more Indian communities. To take an example, there's the Lumbee of North Carolina. They are recognized by the state of North Carolina. They are not federally recognized. And they are a large community, several thousand people. They have been trying to get federally recognized status literally for decades. And there are certainly some recognized tribes in the United States who don't want the Lumbee to get that. And it's because, in large part, because the federal pie is so small. The amount of federal money provided for Indian education and healthcare and development of trust lands and developing tribal enterprises and all of that is a very small part of the federal budget. And if a tribe with several thousand people suddenly get access to that pie, that's a smaller piece for everybody who was already there. And a tribal leader's first responsibility is to the people of their tribe. And regardless of how much sympathy they might have for the Lumbee or for any other tribe that is trying to gain or regain federal recognition, they have to think about their first responsibility. And so that is also sometimes a roadblock. A lot of the successes that American Indians have achieved in land protection, in protection for Native arts and crafts, in the protection and teaching of Native languages, in federal recognition, in all of this, has been the result of one particular organization, the Native American Rights Fund. The Native American Rights Fund. They were founded originally, they were only supposed to last for 18 months. They were a pilot project of California Indian Legal Services. They were established, who was it under? It was Nixon. Nixon was president at the time. And they became, they went from being this tiny little organization with like 3 attorneys to becoming a major law firm with 18 attorneys by the end of the 1970s. And then they moved their headquarters from California to Colorado, which puts them within accessibility reach of more tribes, particularly the large number of tribes in Oklahoma and the Dakotas. And today they have an office in Colorado, an office in California, an office in Washington, D.C., and I think they've got a couple more as well. And they focus a lot on national legislation affecting Native Americans, as well to some extent on state level legislation. They established the National Indian Law Library in Washington, D.C., which probably every tribal lawyer in the country who has served since 1970, or since the establishment of this library at least, has gone to research their treaties, to research legal precedent, to gain the evidence that they need for their tribe's cases in state and federal courts. Today they've got a 13-member board of directors, which is entirely Native American, and they really focus on, their first priority is the preservation of tribal existence. And they also, they work on the protection of natural resources and human rights issues and the government's accountability to Native people. And from the start, NARF attorneys have had notable success in carrying out their priorities. Just in the first couple years they existed, from 71 to 73, they are the ones who lobbied to get the Menominee of Wisconsin restored to federal tribal status. And much of the success in getting federal recognition or restoring federal status to other Indian nations comes from their work. Whether they're working for New England Indian nations or for Alaska villages who are seeking protection from state encroachment, this organization really took advantage of the changing climate. The climate in Washington, D.C., and the attitude toward Native rights that started in the Nixon-Ford years. In 1976, NARF won a major Supreme Court victory. It was Fisher v. Montana. It's Fisher v. Montana. And in that decision, the Supreme Court said tribal courts have exclusive jurisdiction in adoption proceedings in which all parties were tribal members. So if birth parents and the child and the potential adoptive parents are all tribal members, then state courts stay out of it. That is entirely a tribal affair. And then NARF built on that decision 2 years later to support Congress passing the Indian Child Welfare Act. The Indian Child Welfare Act. That, at its foundation, sets minimum standards for removing Indian children from their families. It used to be so common for Indian parents to lose their children for things that they should not have lost their children for. There was, particularly in the 1950s and 1960s, there's what some tribal elders will call the lost generation of children who were effectively stolen from their families and adopted by white families. And that happened in the United States and in Canada as well. And the Indian Child Welfare Act sets standards that says just because parents are poor, you can't take their kids away. You have to actually prove abuse or neglect. The Indian Child Welfare Act also established standards for foster care placement and for adoption. So priority in foster care placements and for adoptive families is that they are of the same tribe as the child who has been removed. So it's harder to remove children, and they ought to be adopted by members of that same tribe if there are tribal members who are willing and able to do that. Now, if there aren't, then they can be adopted outside of the tribe. But that is a decision that will be made by the tribal government, not by state courts. That helps to promote the stability of Indian families, and it also allows tribal courts self-determination on such an important issue, on who is going to raise the next generation of who could be your tribal leaders. Now, ever since it was passed, it has been challenged. There's another case, I think I think the new one's out of Arizona, arguing that this violates the Equal Protection Clause of the 14th Amendment. That's bullcrap. Challenges to this act have been struck down before. This one's probably going to be struck down if it ever hits the Supreme Court. They may just decline to hear it entirely. NARF achieved another really important victory in 1980. That allowed Indian tribes in Maine to receive a settlement for violation of their treaties, a settlement that they could use to purchase back 300,000 acres of their traditional lands. So because of NARF's actions, this grouping of tribes, it's the Penobscot, Passamaquoddy, and I think the Holton Band, were able to regain some of their homelands. There have been a lot of cases that NARF has been involved in for the returning of tribal lands or for payment so that then they can buy back their tribal lands. That has gone on for the last 30, 40 years. Hard-fought NARF victories have also been achieved in the area of human rights, especially concerning the sanctity of Indian remains and the repatriation of burial goods. Thousands of Native people were dug up from their graves in the United States and were held in universities and museums and state and federal agencies and roadside tourist attractions. In 1868, the U.S. Surgeon General ordered the Army in the Plains to find him Indian skulls so that he could study. Back then, some doctors believed that you could tell how intelligent people were by how large the inside of their skull was. Because if you've got a big skull, you can have a bigger brain. A bigger brain clearly means you're smarter. So he wanted these Indian skulls so he could measure the inside and tell how big on average Indian brains were, and thereby prove that Indians were not as smart as white people. And 4,000 heads were taken from the graves of Native peoples, parents and grandparents, and brothers and sisters and children, and sent to the Surgeon General. And then they were just kept in a basement in Washington, D.C. So this is clearly wrong, and through the leadership of NARF attorneys, this issue has been a major focus of their legal efforts. NARF took that issue up long before there was a major, large-scale public outcry. They got the Supreme Court. In 1982, there was a case called Charrier v. Bell. Charrier v. Bell. Charrier v. Bell. And NARF attorneys successfully argued that artifacts dug from graves in Tunica Indian burial grounds belonged to the Tunica tribe. And so the entity that they were suing, or that they were helping to sue, needed to return those to the Tunica people. And then they continually pushed for laws that would protect Native graves. And as a result of their efforts, in 1989, the state of Nebraska was the first state to explicitly protect Native graves. They passed a law expressly intended to assure that all human burials are accorded respect for human dignity, regardless of the ethnicity or the cultural background or the religion of the people buried there. And that precedent-setting law required any entity in Nebraska that had tribally identified human remains or grave goods that they knew belonged to certain tribes had to be returned to those tribes if the entity that held them received any kind of state funding. So like Nebraska State University had a whole bunch of Indian artifacts that now they are going to have to repatriate. They will have to send back to the tribes that they know those objects came from, if the tribe wants them. And that Nebraska law became the foundation for NAGPRA, the Native American Graves Protection and Repatriation Act. The Native American Graves Protection and Repatriation Act. That was signed in 1990 by the first President Bush. That increased protection for Indian graves that were located on federal land and on tribal land So increase the punishment for anybody caught disturbing those graves. It also provided for native control over any items gotten from those lands in the future. So if they're building a highway through Quapaw land, or actually let me use a for real example. In Massachusetts, they're building a roundabout, or attempting to build a roundabout in Northampton, Massachusetts, and they've discovered the remains of a village, and they're not entirely certain. They think it's about 10,000 years old, so they're not. It doesn't correspond necessarily to any currently existing tribe, but the Wampanoag are kind of the cultural advisors on this particular case, and so there's a discussion of, well, first of all, a discussion of whether construction needs to pause while archaeologists conduct a more thorough survey, and then of what needs to happen to any objects removed from that site. Who does it go to? And that is a part of NAGPRA, the respect and the native control over objects found in federal land or native land. It also outlawed the commercial traffic in human remains, which, can you believe they even had to make that a part of the law? Don't sell people's grandmas. But you can't do that anymore. You used to be able to. In 1989, you could sell somebody's grandma's skeleton. Now you can't. It also, and this is the part that a lot of people really hate, which is hilarious, it required all federal agencies, all federally funded museums, all universities that get any kind of federal funds, literally any organization in the United States that gets any U.S. federal money, it requires them to inventory their collections of dead Native people, inventory their collections of funerary objects, cultural objects, or anything of Native origin, make an inventory list. We have this beaker, and it comes from the Osage people. We have this basket, and it comes from the Maka people. To do that and make those inventory lists available to the tribe. And if the Osage say, hey, we want our beaker back, then that museum that has made that inventory has to send it to them. And if the Cherokee Nation says, you know what, we are full up on arrowheads, we don't need any more frickin' arrowheads, you just go ahead and keep our arrowheads, then they don't have to repatriate it. Then the museum can keep those arrowheads on display. But if at any future point the Cherokee Nation says, hey, you know what, we do actually want those, the museum has to give it back. Now, there are ways around this. If you are a museum curator and you're a little bit shady, and you have a globally recognized collection of Native cultural objects, and you don't want to give any of that up, because then your museum won't be as famous anymore, you could write up a fake inventory. You could say, we have this beaker, we think it's Omaha, and we have this basket, and we think it's Quapaw, and we have this other stuff, and we think they belong to these other nations, that you know is wrong. Then you send the inventory, and you send pictures of the objects to the wrong tribe. And they will say, well, that's not our stuff. That's not our tradition. We don't want that. And then the museum gets to keep it. There have been some lawsuits about museums doing that. And I don't want to single anybody out. I really don't want to damage the reputation of any major universities in Cambridge, Massachusetts. But I will say that there have been a couple of lawsuits specifically targeting a natural history museum at a university that starts with H and ends with Harvard. And now let's move on. A major sign of cultural resurgence on the part of American Indian nations has been the establishment of tribal museums and educational centers over the past 3 decades. The largest project of all is the Manchitucket Pequot Museum and Research Center. It's in Connecticut. It opened in 1998, and it is connected to the Foxwoods Casino, which is the Pequot Casino in Connecticut there. And what's really wonderful about this particular tribally controlled research center is not just how massive it is and how incredibly impressive it is, but also the fact that at the end of the Pequot War, way back in the 1600s, if you watch the video about that, you'll know that the treaty that ended that war said that the Pequot name should be struck from the historical record, and the word Pequot should never be uttered again. And now if you're driving through formerly Puritan Connecticut, you see gigantic Pequot from the highway. It's awesome. You know, those kinds of tribal museums have become a really noticeable part of Indian life. It promotes learning from early childhood through adult education. And they really help to counter stereotypes. And they also attract a lot of tourists to Indian country. And that movement toward tribally operated museums has been stimulated by reactions against non-tribally owned museums that would allow for the display of human remains. So now after NAGPRA, the tribes have those and can respectfully rebury those remains and then respectfully display grave goods in a way that the tribe wants to do, not in a way that somebody else thinks is okay. The backlash against the disrespectful way that Native artifacts were handled by certain museums, that also led to the passage of several important laws beyond NAGPRA, including one passed in 1989. That was the National Museum of the American Indian Act. The National Museum of the American Indian Act. That allowed, it committed the United States to building an Indian museum on the Mall in Washington, D.C. as a part of the Smithsonian Institute, putting Native history and Native lives on par with everything else, on an equal basis with everything else that the Smithsonian studies and displays. That act also allowed for the Smithsonian to acquire a private collection and to create a satellite museum, so there's a smaller version of it in New York City. But most importantly, as a part of this act that created the museum, the Smithsonian Institute was ordered to consult and cooperate with traditional Indian religious leaders and with tribal government officials, both to create an inventory of all Indian human remains that was still held by the federal government in any way, all funerary objects. It required the Smithsonian to work with the tribes to identify all of that stuff, to identify the tribal origins of all these materials, and to return anything that the tribes want back. And tribal officials could also initiate that process if they could identify and if they could bring evidence to prove their case before the Secretary of the Smithsonian. Then they didn't even have to wait for the federal government to offer it them back. What mostly the tribes chose to do is to have human remains repatriated, yes, so that those can be respectfully reburied or handled in the way that that tribe sees fit. But most of the objects, the tribes have agreed that the Smithsonian can hold as long as they are displayed and treated in a way that is prescribed by the tribe. And one of the most important things that the Museum of the American Indian does is constantly have representatives from the tribes coming to the museum and offering their expertise and offering their cultural background to make sure that what is being displayed is being done respectfully and correctly. And the museum constantly changes. So they showcase different tribes and they showcase different eras of Indian history. So you can almost always find somebody from Ottawa County up in DC at the Smithsonian working on behalf of their specific tribe with the Museum of the American Indian to make sure that their tribal artifacts are being displayed properly. And right before it opened in 2000, 2001, right around then, and there were so many tribal representatives and tribal elders going back and forth from different reservations and different tribal lands across the country to DC to make sure that that opening would be handled properly as well. In addition to changes in education and museums and that side of things, there have also been a lot of challenges in Indian country since the Nixon-Ford years. And one of the big challenges has been the proliferation of Indian gaming. What typically started as usually pretty small bingo operations, along with tobacco sales, that provided Indian nations a little bit of revenue, has since grown into these multi-billion-dollar casinos, with diverse Indian communities owning and operating more than 200 casinos nationwide. And some of them are the little bitty side of the road operations, like when you drive down through southern Oklahoma and it's like a gas station that's owned by the tribe and they got 2 little slot machines in there, to Foxwoods, or to the new casino that I think, is it the Choctaw Casino? That is the biggest in the country now. Between those extremes, gaming has grown into a significant industry in Indian communities. Gaming operations expanded enormously during the Reagan-Bush era. Those two presidents, it's Reagan and the first Bush, they viewed Indian gaming as a good substitute for federal money. So the more money a tribe was making from gaming, the less the federal government wanted to provide to them, which is a violation of the contracts. But in 1987, there was a Supreme Court case. This is California, the Cabazon Band of Mission Indians. California, the Cabazon Band of Mission Indians. It's Cabazon. In that case, the Supreme Court held that federal and tribal interests preempt any state law when it comes to regulating or prohibiting bingo games run by Indian nations. So there were some states that just did not allow gambling at all. And if there was a tribe in their state that wanted to operate a bingo hall, then the state would try to shut them down. And the Supreme Court said, states don't have the authority to do that. The Indian tribes can operate their businesses as long as it doesn't violate federal law. But we don't care if it violates state law. The following year after this case, Congress passed the Indian Gaming Regulatory Act. The Indian Gaming Regulatory Act. And that set the parameters for Indian-run bingo operations and also allowed for the expansion of tribally licensed gaming up to the establishment of tribal casinos. And that law specifically said that Congress supports this to promote tribal self-sufficiency. The law also recognized that Indian tribes have the exclusive right to regulate gaming activity on their land. as long as that gaming activity is not specifically prohibited by federal law. The act created the National Indian Gaming Commission, which is it's a regulatory body inside the Department of the Interior. And that requires tribes to enter into agreements with the states regarding gaming activities on Indian lands. And the Secretary of the Interior has to approve each of those agreements. So for, all of the casinos that we've got up here in Ottawa County, those tribes have entered into an agreement with the state of Oklahoma, and the Secretary of the Interior has approved those agreements. Now, if you pay attention to the news in the last several months, maybe to the last year, there's been some tension between the tribes and the state of Oklahoma over those gaming agreements, with some tribes saying that the state of Oklahoma has exceeded its authority. We're not exactly sure what's going to happen with that. A number of Indian nations have taken that path of building casinos, seeing it as a way to guarantee economic self-sufficiency and provide services to their citizens. Other tribes see it as surrendering their sovereignty, because they do have to make those agreements with the states, and they are separate and sovereign nations. They should not, in their view, have to make an agreement with a state. Even if the Secretary of the Interior approves, doesn't matter. They should only have to deal with the federal government. And still other nations are extremely wary about the negative side of gaming. They're worried about gambling addiction. They're worried about the criminal element that comes in with large-scale gaming. Most tribes that are starting their gaming operations don't have a great deal of money, so they do partner with outsiders. Those outside entities are not always fine, upstanding people sometimes. And then there's, especially if you're kind of in the borderlands, if you're on a state line, or you're at one of the national borders, casinos seem to attract some trafficking activity. And that's something that we've become increasingly worried about in the last 10-15 years, especially up here in northeastern Oklahoma. Trafficking taking place in massive parking lots in the casinos. There's been a lot of talk and quite a lot of law enforcement keeping an eye on. Man, I just had the biggest brain fart. Why can I not remember the name of that particular casino? I can't, anyway. But there is worry. So over the past 3 or 4 decades, there has been a really remarkable makeover in Indian policy. And for the first time, there's been an acknowledgement that American Indians have a distinct status in the American body politic. And American Indians are no longer willing to be administered in a paternalistic colonial relationship. And so they've asserted their rights as Indians and as American citizens. In '94, President Clinton addressed 322 leaders of federally recognized tribes at the White House, issued a major policy statement, probably the most important one since President Nixon's. And Clinton committed his administration to a government-to-government relationship with Native tribes. He talked about it, trying to ensure that the rights of sovereign tribal governments would be fully respected by federal agency heads and by their staffs, who he said would supposed to work to build a more effective day-to-day working relationship, reflecting respect for the rights of self-government that were due to sovereign tribes. Now, today, obviously, there's still a lot of racial discrimination, still a lot of poverty, Still a lot of state meddling and intransigence on taxation and jurisdiction and all other areas. But there have been so many improvements. Now, tribal leaders still look on Washington with some suspicion, well remembering the broken promises and broken treaties of the past, and with concern that even though we've made some steps forward, we may also take some steps back. But we also need to recognize that in the years since Alcatraz, tribal concerns have not been completely satisfied, but have been acknowledged, and positive steps have been taken. So in the next lecture, we'll talk about some 21st century issues, some of those things that can change very rapidly. So yeah, we're at the end of lecture 9 then.